And let's welcome in right now Adam Thompson, defense attorney who shuffles between Florida and New York. Not a bad place to shuffle between, Adam.
Thanks for having me on. Yeah, no complaints there.
Okay, well, all right. So I'm bringing people up to date. And today the 5 witnesses, and then the 2 police detectives, the detective in charge of the case, and the other police officer who's a female who testified for the prosecution, and then I believe wound up being better defense witnesses even on cross. They testified, the detective testified that when he played the 911 tape that had the screams for Trayvon Martin's father, he said, "Is that your son?" And Trayvon Martin's father said something to the effect of no. The female police officer was in the room. She backed up what she had heard. No. Then I'm confused. Now, maybe you could tell me. I was confused until the end, and then I got more confused because I'm trying to watch this while I'm doing my show. We're reading the closed captioning. But the defense then called Trayvon Martin's father to the stand. And I'm thinking, why are they doing that? The prosecution can't call him anymore. You already had the 2 police officers saying that he said no. Why did they bring him to the stand? And then I heard the end where they accused, I think, Mark O'Mara, the defense attorney, accused the father of telling the family attorney to lie. So fill me in on this whole why they called Trayvon Martin's father when apparently they had a win on that already. And was it because of this last question? And what does that all mean?
Well, I'm of the opinion that less is more, and once you score your points and you get the win, like you said, you leave it alone. Calling Trayvon Martin's father was a very, very risky proposition because it could open the door to have him say things that could really damage your case. You know, he's clearly not a defense witness. He's a prosecution witness. It's his son who died. So you know what he's going to say and what he's going to try to do. I think the point you wanted to get out was just that, look, this guy knows his son, loves his son, spends tons of time with his son, as much as the mother does, and yet when he heard the tape, he made it clear, that's not my kid.
Well, we should point out, Adam, and I'm sure you're aware, I saw the stepmother interviewed by Anderson Cooper on CNN. The real mother, the mother who testified, didn't spend a lot of time with Trayvon for a lot of years. According to the stepmother, she raised him. So that's for the record. The father, on the other hand, said today on the stand that he was my best friend. So the father should know better.
Absolutely, and that's going to be a huge point that the defense is going to bring up in closing arguments. I think what they were trying to do today, again, drama goes a very long way. I think at the hearing, the officers again reconfirm, hey, we interviewed the dad. It was a timely interview right after it happened. The tape is fresh. He hears it, and he knows we're conducting an investigation, trying to get the suspect and try to lead to a prosecution. And when he's asked these important questions, his answer was no. And it wasn't just one police officer that heard it. It's
2.
corroborated by another.
Okay, so let's stop. So why did they then? So good. Again, I'm not a lawyer. I try to play one sometimes on radio and TV. So you were thinking the same thing I was thinking. What the heck are they doing calling the father?
What are they doing? You hit a home run. What do you want to run around the bases twice?
Right. So why? So but you saw the testimony. You heard it. Do you think damage was done? And what was that at the end that I caught out of the corner of my eye? Did you ever tell anyone to lie? You did not? You mean to say you did not tell Ben Crump to lie? What is that?
I think the reason and the rationale behind that is they want to say, look, the dad's got to be truthful because too many people heard. He's not going to debate and argue that point that he said it wasn't him. So now the only really weak link then is the mom saying it is my son. So you kind of raise an innuendo by saying, hey, Trayvon's dad, did you speak to the lawyers and say, let's make the testimony all match up a little bit? Did you tell them, this witness may say this witness may say that. If it all doesn't, go together, you make it fit a little better so the puzzle looks a little cleaner. And if a jury thinks that, then they may think, hey, maybe the civil lawyers got together with the family, had a powwow, went through what the testimony was going to be, and they said, you know what? You can't go in the room and say you're not sure it was your son. You really don't know if it was your son. You got to say it was your son.
All right. So again, because you know more than I. You were watching it, and I was watching with one eye. So you don't think Crump? Well, Crump was not allowed to stay in the courtroom. the civil attorney for the family, during the trial because apparently he was going to be a witness. Now, to the best of my knowledge, recollection, he was not called by the prosecution. Correct me if I'm wrong. Do you think now that Amera has something concrete that he's going to call Crump and Crump is going to say, yeah, he did ask me to do something and he just lied under oath? Is that possible?
Anything's possible. I would really doubt that that's going to happen because conversations between a client and an attorney are privileged.
Okay.
And I really doubt he's going to take the witness stand and throw his client under the bus over a conversation that would happen behind closed doors that no one would know or be able to document.
Okay.
So he's just going to say, no one ever said to lie or make up a story or make it fit. But, I just think they wanted to give the inference to a jury that maybe such type of conduct went on. And, hey, listen, this is the theater of law. If you're going to get a jury thinking about it, or you can get a jury talking about it in a jury room, that's just another way to peel back, that level of reasonable doubt.
Gotcha.
And if there's just any reasonable doubt, they could acquit.
Well, theoretically, they're supposed to acquit. You're absolutely right. We're talking to Adam Thompson, a defense attorney from New York and Florida here on the Steve Malzberg Show. And not only were there the 5 witnesses and the 2 police officers, the 5 witnesses who said it was George Zimmerman's voice, and we're talking about all kinds of people, including a former military person who didn't want to testify because it brought back all kinds of horrific memories, but he recognized those screams. We also had the 2 police officers who verified that Trayvon Martin's father said it was not my son's voice. But we also had an athletic trainer. The prosecution brought up that George Zimmerman told actually the woman, the medical technician, brought up that she had previously seen George Zimmerman. He had told her that he did some MMA training or whatever the heck it is, fighting. Long story short, the trainer, George Zimmerman's trainer, said this guy did not take this course or these classes to learn to fight. He did it to lose weight. He lost 50 to 70 pounds. He was way overweight. He's a terrible fighter. He's not a qualified fighter. He couldn't hold his own with anybody. I mean, there again, more ammunition for the defense.
Sure. I mean, a lot of the points made by the prosecution were much to do about nothing. There's many people that take, these boot camp courses, and they're very strenuous things. Some of them involve learning kickboxing or boxing or mixed martial arts, whatever it is. And it's just to lose weight or get in shape. It's not like you're taking it to become some, serious caged fighter. And that's what I mean. When the prosecution is going to be presenting points like that, and then they fall flat because they really don't have substance behind them, a jury starts to question the overall credibility of the whole case. If it's just like a witness. If a witness testifies and you disbelieve part of the testimony, particularly on a material topic or a material point, the judge is going to instruct them, and you could discount the entire testimony that they offer from beginning to end. And that's what's going to happen a lot here, from Rachel Jeantel, who said a lot of stuff that she lacked credibility on and she came off so poorly in front of a jury, to other witnesses. It's just, when you take it all together and you fill in all the gaps, it's not a strong case.
All right,
and I can't even see how they even brought a second-degree murder charge.
Well, I don't understand how this judge did not throw that out when upon the motion made by the defense on Friday. I mean, I wasn't expecting her to.
That never happens. I mean, the judge always punts.
They do? Okay. But this judge. Now let's talk about Rachel Jeantel for a second. And I'm sure, I am sure that the defense could have thrown the dice and asked the mother and now the father about your son's use of the term crazy-ass cracker, but I think they're going to let that stand on their own. But this witness was so disrespectful that it's my opinion that if this, well, let me ask you, and the media crying for this girl. Oh, she's only 19. Oh, it must have been so hard. Only 19. Men go off to war and die at 19. So this only 19 nonsense was just that nonsense in my mind. But she was disrespectful. She made faces. I mean, to me, a judge who was in control of her courtroom and a fair judge would have reprimanded this woman and said, hey, cut it out or you'll face contempt of court. Show respect. But that never happened.
It was a completely poor presentation. You would think for a case that's so in the media and so scrutinized under the microscope that every single radio and TV show is talking about it, that this is the star witness. This is the last person that heard Trayvon Martin speak on the phone. You would think she would have came in with all the bells and whistles, totally prepared, ready for the questions that she was going to be asked, and give very succinct, concise answers and be ready for cross. And most important, textbook 101 law, prepare her for the basics as a witness, proper decorum, how to respond, be polite, always maintain your composure. It was completely the opposite of that. This would have been a course on what not to do with a witness.
But do you agree that let's put it this way, in other circumstances, this 19-year-old woman would have been read the riot act by the judge?
I think because this is being televised, I think she's keeping a hands-off approach and basically not really taking that stand with any of the witnesses, and she's trying to keep everything clean in front of the jury so that when something comes up, she calls for a sidebar,
right,
will talk to the attorneys. She's not really looking to create a situation where there could be appellate issues and things like that. So she's trying to keep it clean. I think she's doing that to both sides. But in general, if you normally have a case and it wasn't televised like this, you had a witness that would act in that manner or with that kind of decorum, I think certainly a judge would say something.
All right, one more question for you. Based on if the trial ended today, is there any way that if the jury does what the jury is supposed to do, that this man spends a day in jail?
Never, not going to happen. The odds of him getting convicted are like the Powerball. But let me say one more time, never.
All right, well, I hope you're right, because I have felt that the evidence, as it came leaking out even before the trial, had to raise a reasonable doubt, and you're right, and the prosecution trying to make points, the father, two cops just said the father said, no, it's not my son's voice, and the prosecution gets up on cross and is like, I'm sure you miss your son. Well, you know what? That's nice. That's sympathy, but that doesn't address what you said to the detectives.
What does your son have to do with who is the initial aggressor, and did you defend yourself against deadly force?
Right. Well,
that's the issue.
Absolutely. And if another misnomer is that the injuries were small. You know better than I. In Florida, as was described by the defense witness, stand your ground or self-defense. You don't even have to have a blow to perceive you're in bodily, grave danger or severe bodily harm. They don't even have to land a blow. So the media has distorted this whole case. Hopefully the jury will understand it. Hey, nice talking to you, Adam. We'll have you back. Thank you.